Steel, Transpacific Export Services, and the State and another.
Mr. Torbooth.
Maybe Your Lordship.
Good morning.
Good morning. I appear together with my friend German and Chakwa.
Yes, good. Well, Mr. Chukwu can sit down for the moment. Thank you.
My Lords, I have noticed that the issues have been significantly narrowed down.
Good.
The two issues which are left to be argued upon are, one, whether the Court of Civil Appeals judgment respected the constitutional rights of the appellant.
Can you repeat that, please, Mr. Torbooth?
Whether the Court of Civil Appeals judgment respected the constitutional rights of the appellant.
Yes.
If I were to give the simplest answer to this question, I would submit in the negative that it has not done so. As to the second issue, whether the law of Mauritius requires a plaintiff to plead and prove bad faith in a claim against public officers. If it means that the plaintiff had to aver bad faith, the expression bad faith, I would say no.
No need to plead it, but a need to prove it?
But the need to prove is there.
Is there? Very well.
And this can be done by the affirmative facts as per the plate. And at the end of the day, whether it's a bad faith or good faith, it is for the court to decide. It is not because the plaintiff said, avers bad faith, that this is necessarily correct. Immaterial about the standard plaintiff at the start, what the court requires is that the facts averred have to be proved, and it is for the appreciation of the court on the basis of the facts which have been approved, which have been averred and proved, whether it can be inferred that the respondent acted in bad faith or good faith.
Thank you for clarifying the issues. That's most helpful.
My Lord, before I proceed further with these two issues, I wish to invite Your Lordship to the case for the respondents.
Yes, which paragraph?
Yes.
What's the point we're going to, Mr.
The point is that the respondent seems to suggest that, at paragraph 13 of the, which is page 5 of the, that they seem to be denying that the facts stated it is the case for the appellant that these are admitted unchallenged facts. But the respondent seems to suggest that the goods which were seized were lawfully purchased and lawfully cleared for custom after payment of revenue and taxes. And they went on to, this was not admitted, no unchallenged. May I therefore now refer Your Lordship to the plea of the respondent, which is to be found the main bundle at page 38.
30?
38,
38. Very well.
paragraph 2.
Well, wait a minute. That's the revenue authority. Do you want that, or do you want 35? Which is it?
Your Lordship, are with me?
35 or 38?
38. Paragraph 2 of the plea of defendant number 2.
Yeah.
Yes.
May I read my note?
Right. Right.
And this,
I think, Mr. Torbuth, I think the point is this. If you've got your case, page 6, submissions, A, admitted unchallenged, have you got that to hand? Admitted unchallenged facts, paragraph 1.1. You say, admitted and unchallenged, the goods which were seized, lawfully purchased, imported into Mauritius, lawfully cleared from customs after payment of the relevant duties and taxes.
Yes.
Well, no doubt we all underlined that.
yes,
But then we read what you're now referring to, which is plea of defendant number 2 on page 38. And we saw that what was admitted was payment of the relevant duties and taxes based on the declaration made in the bill of entry. So what was admitted was that your clients had paid the duty on what they said were the goods and the appropriate amount of duty. It's not accepted, Mr. Guthrie makes this clear, that you'd paid all the truly payable amount of duty.
that's why I wanted to clear this point.
Well, thank you very much.
Now, if that was the case, it is my submission that it were incumbent on the respondent to send in their claim and to justify their claim. And this is what the appellant had tried to do. They suggested a figure of 800,000 rupees, approximately, but they never came forward with any claim, with any justification. It was just a sweeping statement. Whereas, in paragraph 2, they admit that the goods referred to paragraph 2 of the plaintiff's summons were imported in the name of the plaintiff and cleared from the then department after payment of the relevant duties and taxes based on the. There had never been any proviso that, but had they averred that not all the duties were paid, then this would have given been a ground for the appellant to take remedial action and to seek further clarification. But there is no proviso.
Were you not prosecuted for under-declaration?
There was a prosecution
For under-declaration?
for, I may put it, Your Lordship, with due respect, for alleged under-declaration.
Yes, quite.
What happened?
So you can't have been in much doubt that they said there was more owing than you'd paid?
Yes. And then the representative of the plaintiff was convicted.
Quite.
How matters went in the intimate court, we cannot say. We can only guess. But he was convicted, he was sentenced.
Mm-hmm.
And then the appellate, on appeal in the criminal case, the conviction was dismissed and so was the sentence.
On the basis of limitation?
This was one of the grounds.
Well, it was the only one that was on the only basis on which the appeal was
But-
allowed, wasn't it?
Yes.
Yes.
But the important point is that if Your Lordship will refer to the judgment of the appellate court, at no point in time, I wish to re-emphasize, those exhibits which were taken away from the stores of the appellant were produced in court. Nor was in the sentence any order for the forfeiture of those goods.
Any order for what?
For the forfeiture of the goods.
Forfeiture, yes.
If the goods as exhibits were not produced, there was no order for forfeiture. The question arises, on what basis, after the judgment of the criminal court was quashed, the respondent continued to detain the goods? And there is an admission on their part that the goods were not seized but were detained. The goods were not seized but were detained. And we'll come to the case of Bakewell. It was the case, which is a leading case in matters of detention. He should detain goods for the purpose of an inquiry. And there is no express power under the customs law for detention. But in Bakewell, the learned judges were prepared and they accepted that for inquiry purposes, this could be done. But the longer the goods are detained, the more difficult would be for the party detaining the good to prove good faith. So that, and one can guess, my lords, why the respondent admitted from the start that the goods were not seized but detained. My guess would be that if you seize goods, this has to be done in accordance with Section 143 of the Customs Act. You must issue a notice of seizure. And you
I
must
noticed that point in your case, Mr. Torwood, and I wondered whether that was a point that had ever been made before. The obligation under Section 143.
Yes, it didn't arise because they admitted that the goods were not seized. I'm just trying to guess.
I see. Very well.
It could not be made because it was raised. But had they raised the point that the goods were seized, then this would have given rise to raising that point of unlawful seizure.
Thank you.
So, we are at this stage, and our case is clear. Whatever may have been done during the first part until conviction, but once the appeal was allowed, there was no longer any reason, or at least any legal basis for the continued detention of the goods. And the plaintiff, the appellants today, did not remain quiet. After the dismissal of the conviction, they wanted to find out the state of the goods and to have a survey of the goods with an usher of the Supreme Court. They were denied access. They had to seize the Honorable Judge in Chambers for an order, and there were negotiations, which unfortunately didn't materialize, which brought us to a civil case, to the appeal in the Court of Civil Appeal of Mauritius, and we are here today.
Yes. Now, you said that the first issue was the constitutional point.
Yes.
Do you want to elaborate on that?
Yes. My Lord, this first point raises a number of other questions. Was the action of the respondent taken under lawful authority? If they were in power under the Constitution to do that, then they would have been perfectly entitled to do it. They would not have been in violation of the constitutional right of the appellant. But
so what constitutional provisions are we talking about, Mr. Talbot? Should we just note them or look at them briefly?
denial of the protection of the law. And linked to that, because the goods were unlawfully detained, denial of the right of the appellant to property, or right to property.
Which article of the Constitution?
Section 10, Section 8.
Now, these are in your additional list, aren't they, Mr. Torbu?
Yes, my lord.
Right. Section 10. 10.8, is it?
Yes, my lord.
The entitlement to a fair hearing.
Yes. Now,
And then you said, let's just make a note before we go any further. You said Section 8, protection from deprivation of property. Yes, very well.
so our Constitution, the framers of the Constitution, in all fairness, they have made, and this is our supreme law, goods can be seized, persons can be arrested, provided they fit in the derogation, if they act in accordance with positive law. But in this particular case, there is no power under the law to detain goods for such a long time. Although I said in the case of Bike World, the Privy Council accepted that for purpose of inquiry, some degree of detention is permissible, but not for years you detain the goods without any power. And this, in my submission, is a denial not only of the constitutional right of the appellant to law, protection of law, protection of right to property, and also it offends, as a matter of common sense, fairness.
So is this the argument, Mr. Talbot, that the detention may well have been lawful, detention may well have been lawful originally, but it became unlawful?
Yes, it might.
Could you just show us where that argument was advanced either to the judge or to the Court of Appeal?
Yes, my lord. I will...
Well, let someone else look for it, because it will take time if you haven't got it to hand. But are you saying that that is the way the case was put to the judge? Are you?
Yes, my lord.
You are, all right.
Before, in the lower court, the issues were that the conduct in a gist of the respondent amounted to the constitutional right and denial of the constitutional right of the appellant.
I think you certainly said that the detention became unlawful on the date when the conviction was set aside, which, as I recall it, was July 06. Are you saying that that is the date when it became unlawful, or are you identifying another later date than that when it became unlawful?
No, I think that the detention in the way it was undertaken was unlawful from day one. From day one.
What do you mean by day one?
From the time that the officers went there and to seize the goods.
I see.
But for the purpose of the case, we are prepared to admit that even if at the start it would have been permissible to take away the goods, but this ought to have been seized, not detained. Okay? As from the date the goods, the conviction were quashed, there was no longer any justification for the detention.
Right, thank you.
And this is the case before Your Lordship, and this was the case before the Court of Civil Appeal.
Right. Now, what more do you want to say on the constitutional points?
If the goods had been detained, and up to now they are still in possession of the goods, in a very arbitrary manner, without any justification, and at one point in time, when the plate with summons was entered, we were asking for the return of the goods and for compensation for the prejudice suffered. But in the course of the hearing, being on the time which is being taken, the appellants were deprived of access to the goods, to see the state of the goods, and being given that we were dealing with electronic matters, there were no longer they didn't have any market value. So we say we are not going to take the goods at this stage. It was too late. You compensated in money terms. And that's why the plaintiff representative, when he gave evidence in the lower court, he explained how he came to the figure of 35 million rupees, and subsequently that figure was amended to 65 million rupees, and he gave his explanation how he came to that figure. This was it. But on the side of the respondent, nobody came forward to give evidence to contradict the appellant. That's why I say this has gone unchallenged. If you don't cross-examine, if you don't come with counter-arguments, means you're accepting. And when the motion was made in the court below in Mauritius to amend the figure from 35 million to 65 million, there was no objection from the respondent. And it was then that, following instruction received from the client, we dropped the prayer regarding return of the goods.
Yes.
May I refer Your Lordship briefly to, the case of law is very self-explicit as to, let me refer to the case which is relied upon by, before I do that, the Court of Civil Appeal, the judges, found that the trial judge made a serious misdirection.
Those two errors.
Two errors.
We know about them.
Yeah, yes. But still, the Court of Civil Appeal came to the conclusion that this didn't affect the constitutional right of the plaintiff because there was no such argument. Well, the case of Dassault, my lord,
Very well. We've got that in the
which
bundle.
is page 4 to 15 of the brief of general authorities.
I'm sorry, where is this? What page is this in the electronic bundle?
Page 4.
Yes.
Page 4 of number 1. On a small point, Mr. Torbuth, of course we've got your authorities and we've got Mr. Guthrie's authorities. And unfortunately there are duplicates. And that shouldn't happen. and there should have been a better liaison between the solicitors to see that important authorities aren't copied twice. Well, let's get on. Page 4 of your bundle.
Yes.
Yeah.
It is a consolidated bundle, but let's go to page 4.
Now, what are we looking at this authority for? What?
Yes, thank you.
Thank you very much, Mr. Guthrie.
If we turn to page 12, this is what the law lords had to say. And the first paragraph, third line, every person charged with a criminal offence is entitled under section 10(1) of the Constitution to a fair hearing. So the fundamental question for the Supreme Court must always be whether the proceedings are called into question were or not fair. But common sense suggests that some limits must be set on the admission of additional evidence. That was the issue about admission of additional evidence in the course of an appeal. But the point on which I want to make at this stage is to be found at page 14.
Yes.
The second paragraph, actually paragraph 24, almost in the middle. But section 96 must be read together with section 82, subsection 1 of the Constitution, which provides that the Supreme Court may make such orders, issue such writs, and give such direction as may consider appropriate for the purpose of ensuring that justice is duly administered by such court. It is not necessary for proceeding for constitutional relief to be brought under section 17 of the Constitution to enable the Supreme Court to exercise its power. We have in our Constitution section 17, which is part of chapter 2, wherein are incorporated the fundamental rights of the individual. And section 17 is the section under which constitutional remedy is sought. But what this case, this is my understanding of this case, is that we don't have to spell it out. We don't have necessarily to enter a case under section 17. We state the facts, and it is for the court to decide whether, given the circumstances of the case, the Constitution has been infringed in a particular case. So it is my submission before your Lordship that there was sufficient material before the Court of Civil Appeal and the lower court that the constitutional right of the appellant has been contravened in various aspects. And when the matter went to the Court of Civil Appeal, the learned judge accepted first that the goods belonged to the appellant. They accepted that there was a misdirection by the trial judge, but they didn't accept there was any infringement of the constitutional right because this was not averred. Again, this is a question of law. It was for the court to assess, to appreciate, to infer from the fact that there was constitutional breaches in that case. This was not done. And this was the judgment of the Privy Council. And we refer to the following judgment, Sanjay Julan versus the State.
Which one?
The next one, which is at page, we start at page 16. The same bundle.
The Julan case?
Julan case.
Very well.
Mr. Balancy, who sat in the course of civil appeal in the present case, also presided over the case of Julan. Your Lordship would find his name indicated at page 29.
Yes?
And in that case, my Lord, the learned judges at page 19 adopted, they could not do otherwise, rightly, what the law lords had to say in the case of Dasrat. And this is reproduced at page 19.
Well, we see that.
Yes.
You didn't.
And
You didn't issue
Yeah.
proceedings for constitutional
Yeah.
relief under
Yes.
Section 17.
Yes.
You say that you didn't need to
No.
because of Section 82.
Yeah. In that case, it was Section 82, because it was an appeal for the lower court. But we have also, my Lord, Section 15, Section 16 and 17 of the Courts Act, which give unlimited powers of the Supreme Court. Unlimited powers.
I may not be following, but isn't the quotation here set out on page 19,
It
doesn't that relate to criminal proceedings?
Yes.
Yes.
Yes. Criminal proceedings, but when we are dealing with constitutional matters, it also extends to civil proceedings.
Right.
It is my submission. And what is interesting at page 21, in the case of Julan, my lords, the second paragraph, let's start from the beginning. It is to be noted that in Cattery, against R, just as in Dosrat, the court...
Where are you reading from, Mr.
At
Tobin?
page 21.
21, very
Yes.
well. Yes, thank you.
It is to be noted that in Cattery versus R, just as in Dosrat, the court's attention was not drawn to the second problem above. In relation to the latter problem, we agree with Mr. Pirou, counsel for the appellant, that there cannot be two standards of justice in respect of such an important matter. Therefore, there cannot be more important matter than constitutional matters. We don't have to have as such, but it is for the court, who has unlimited powers, to go to the facts of the case and to see, as has been rightly raised in the issues before this article, whether the facts of the case indicate that the constitutional rights of the appellant have been contravened. And I answered the question in the affirmative at the very start.
Can I just check which constitutional right we're talking about in this context? Is it that the first instance judge, the trial judge, got it wrong? Is that the unfairness that we're talking about?
I am speaking at this time, Your Ladyship, about the finding of the Court of Civil Appeal that there was no averment of any constitutional infringement.
Yes, but I'm wanting to know which constitutional infringement could have been averred if it had been spelt out.
In my submission, it would be right to a fair hearing, right to the protection of the law, right to the protection of property.
But in practical terms, that is because the first instance judge got it wrong, and therefore it wasn't a fair trial, and the Court of Appeal got it wrong, and therefore it wasn't a fair trial. Is that the practical manifestation of that breach?
In fact, Your Lordship is right that the Court of Civil was not prepared to accept that there was an infringement of the constitutional right. In fact, the Court of Civil Appeal condones the finding of the lower court, which set aside the case in the lower court on the sole ground, not on the sole ground, but one of the ground was footload, and about there was the plaintiff was not able to identify the goods. But when it came to the Court of Civil Appeal, it was agreed, the Court of Civil Appeal agreed that the goods were properly identified, there was a misdirection, that, and this was conceded by the respondents.
Yes, there was an acceptance. The goods had been properly identified,
So
but there was no doubt that the goods were your property.
But
Those were the 2 points. We've got those well in our heads.
But when insofar as the question of consular rights being deprived, the Court of Civil was not prepared to accept their arguments.
No, but you haven't answered my lady's question. Assume for the moment that you're right, that you don't have to put a heading in your claim, breach of constitution. Assume that on the basis of Desaruth and Julian, it is enough that what you demonstrate adds up to a breach of a constitutional right. What you were asked was, where is the breach of Article 10? Where is the unfairness? Is it simply that the judge got it wrong, or is it something else?
In my submission, the judge got it wrong.
Well, I know you say that, but do you also say, therefore, it is unfair? Just by itself, that's enough, is it?
It is unfair to the extent, it is my submission, my lord, to the extent that once I am speaking about the judges of the Court of Civil Appeal, once the judges of the Court of Civil Appeal came to the conclusion that the judge in the first instance had misdirected himself.
Made the 2 errors that we've talked about.
Yes.
Yes, go on.
Yes. And when, therefore, and he accepted that.
Yes.
Therefore, in the lower court, it would be a submission that the appellant was denied a fair hearing.
Is the breach of the fair hearing the 2 errors that the judge made? Is that it?
Yes, my lord.
Is there anything else?
There was also the fact that at the end of the day, the judge said that there were no averment of footload.
Right.
And this point was taken over by the Court of Civil Appeal.
Yeah.
This is where, if the Court of Civil Appeal rightly found the judge was wrong, and then he continued by saying that there was no constitutional infringement, yet he said, but the fact that footload was not averred and proved, therefore the case falls.
Right. So what I've written down, Mr. Turworth, is this. There is a breach, we say, of Article 10 of the Constitution, denial of a fair trial, first because of the 2 errors of the judge which were identified by the Court of Appeal, and secondly, we say, because of the judge's additional error in holding that footload had to be averred and proved. Now, is that a complete summary of what the breach of Article 10 consists of?
So far Article 10 is concerned, that would be okay.
Right, thank you.
Then we have Section 3 about the protection of law, and then Section 8 about deprivation of property.
All right, well, the same question arises in relation to Article 3, breach of the protection of the law. Is there anything other than the 2 errors and the footload point which creates a breach of Article 3?
my submission, I cannot identify any more.
No. So it's the same point. Thank you very much. Got it.
Well, I wonder whether that rather neatly moves you and us into your second point, which is indeed the need to aver as well as to prove faute lourde.
Yes. Now, again, we come back. This question of faute lourde is, again, as I said earlier on, is a question of law. Yeah. It is a question of qualification. And it is settled law in Mauritius that, and in the UK, we borrow from UK, not only the sense of fairness of the British people, but also about the importance of the protection of law. It is settled law that you don't have to aver the law. You tell me the facts and I will apply the law. Yeah. Okay? So, and what is faute lourde? It can be anything from a simple faute to a most serious faute. Okay?
Can I just be clear before you develop these submissions? Are you agreeing that faute lourde has got to be proved in this claim?
Yeah.
Yes.
Any faute has to be proved. Whether it is lourde or not has to be proved.
Well, no, I'm asking whether you're agreeing that faute lourde has to be proved as opposed to a simple fault.
I have some reservation because, as indicated in our submission, our law, Article 1382, Article 1383, Article 1384 of the Code Civil Mauritius doesn't speak about faute lourde. This has been borrowed from the French, which may be true in certain circumstances, administrative decision. Okay? But in our law, there is no such positive law where it mentions faute lourde.
Okay, so you're not agreeing that it has to be established.
But assuming, let me assume that this has to be proved, it would be my submission that somebody cannot be pretending not to have committed a serious mistake when he would be acting under unlawful authority. So to the extent that the prolonged detention has been done without lawful authority, if faute lourde has to be proved, there cannot be more serious fault than somebody, an administrative body, acting without lawful authority, denying a citizen of his right to the protection of law, of his right to property. If this is not assuming that this has to be proved, this is faute lourde, unless the respondent has another definition of faute lourde. So even on that assumption, it is my submission, the facts which were before the lower court, the facts which was the Court of Civil Appeal, clearly demonstrate that the respondent has throughout acted without lawful authority, as was done in the case of Bakewell. The law lords who decided Bakewell did not insist on faute lourde. Bakewell, your Lordship, my Lord, would be at page at page 32.
32, yes.
Yes, you know all about this case. I think you were in it, Mr. Torwood.
Yes, my Lord.
Yes, very well.
And what is important in my word is the legal reasoning of the lords. How they tackle the problem of detention, how it came they brought in the question of lawful authority, and somebody who acts without any lawful authority cannot claim to get out.
Well, what do you want us to get out of Bike World, Mr.
Backward,
Because looking at page 47, right at the end of the paragraph before the number 30, so it's the end of paragraph 29, it looks as if the reason for the decision was that once the importers had tendered, admittedly under protest, the sum that was claimed, there could no longer be any basis for the detention. Is that right?
yes, yes, my lord.
Yes. How does that help us in your case?
The gist, in my submission in the case of Baker, that there was no probable cause, as in the present case, and the test would be an objective test, whether in the given circumstances the respondent was entitled to detain the...
No, you see, that's not what it says. What had happened in Bike World was that a plea in limine had succeeded, despite the fact that the money had been tendered. And all that their lordships were saying was, if you've tendered the money, you can't strike out the claim in limine. How does that help us in your case?
No, there the facts differ to the extent that there was the custom claim that the classification was not the proper classification, it was a wrong classification, and it attracted a higher rate of duty.
That's right.
And the appellant was prepared to pay for that. They refused because they said they have already committed an offense. Mm-hmm. Okay? And in that case also, it is similar to the case to the extent that the goods were not seized. They admitted it was not seized, but it was detained.
Yes. And
there was no notice of seizure. But what is the concluding paragraph of the Backwell sums up. Their lordship do not, it is at page 46, their lordship do not need to deal with other arguments which were advanced by counsel for the appellate in support of the appeal, except to say that it does not follow from the conclusion which they have reached that the course of action on which the first respondent embarked was without probable cause, that the derogation in section 847 of the Constitution from the right not to be deprived of one's property in respect of accident and the authority of the law don't apply in this case. But the evidence which has been led so far falls short of what would be needed to bring the case within that derogation. In that case, there was some evidence, but in our case, there was no evidence at all coming from the respondent.
Yep.
Very well. So you say that from the facts you proved the only reasonable inference was bad faith.
Yeah.
Very well.
On one last point, my lord, on the question of footloot, the issue of footloot was never part of the case of the respondents. Was never part. It came out of blue in the course of the submission.
I understood it was part of your case, but your argument before this court is you didn't have to aver that it was part of your case. Yes. Because it's a matter of law.
I understand. But they, on the other side, they never raised that point also in their plea. There was no argument which could demonstrate that we had to have a footloot.
Well, you don't have to put that in the defence any more than you have to put.
Yeah, I quite agree. But I'm not.
So let's not worry about that.
Yeah.
Could we go to page 63 of the record, please, Mr. Torbut?
Page 63.
Page 63, if you've got that to hand. Now, here's defendant number one, the state. In September 2013, which was well before the hearing before the judge, asking notice to amend its plea by raising another plea in limine litis. And the plea was that your plaint be dismissed, you'd failed to identify the préposé, as well as plaintiff has failed to aver the faute lourde allegedly committed by these préposés. Now, correct me if I'm wrong, but it was later decided in 2014, I think, that that point would be rolled up with the main hearing rather than disposed of as a preliminary point. But when you say that the respondents never raised faute lourde, what do you say about page 63?
Yes, there was an attempt to amend the plea by introducing a plea in limine. Okay? And after an exchange of views between the bench and the counsel, it was decided that this issue could be taken on the merits. But, my lords, the respondent did not adduce any evidence to prove that the foot which we were pressing was there was no argument, because no evidence at all was adduced by the respondent in support of the point they wanted to take on the merits. And was it permissible for them at this stage also? That's why the case of auteur comes to play. Auteur is to be found at page 48 of the bundle of brief.
Yes.
Auteur, my lords, it is an 1862 MO 153 judgment, and where the provisions of Article 173 of the Code de procédure civile was referred to. Toute nullité d'emploi ou d'acte de procédure est couverte si elle n'est pas avancée avant tenter de défense en exception, outre les exceptions de la compétence. Les exceptions dilatoires seront proposées conjointement et avant toute défense de fond. So,
can you translate that, please?
Yes. If you want to raise a plea in limine, it should, in a civil case, in accordance with Article 7, this has to be raised at the very start. If you have not done it, means that you have condoned it. You cannot come at a late stage to come with that, unless you are challenging the jurisdiction. The only challenge can be done at any stage of the proceeding is that of jurisdiction. If it is not of jurisdiction, if it is based on facts, you will have to have a facts and to raise a point in limine at the very start of the case.
Thank you. Yes.
Anything on which your Lordship would like me to enlighten the board?
Well, let's see whether my colleagues have any questions.
No, I think I've got it.
No, thank you.
Mr. Torbut, thank you very much indeed.
Thank you.
Let's see whether Mr. Chukur is going to follow. Very well. Well, we'll rise now for a few minutes to decide what to do next.
My parents, my lord.
Mr. Guthrie, we'd like your help on a particular point, unless there are other points that you want to, as it were, highlight for us. The particular point is this. We think it was in July 06 that the conviction was set aside. So let's take that date. The goods remained detained after that date by the police. There had been no seizure in the strict sense. There appears on the evidence not to have been any ongoing investigation from that time onwards into the matter. And so continued detention after the conviction is set aside is the only reasonable inference from that, or is it a possible inference that the goods were being detained in bad faith?
Well, certainly, my lord, I don't go outside that, I don't think.
Very well.
To deal with
Yes,
other matters,
very well.
I don't think
Yes.
take up that invitation. But I think it is really necessary to look at the way in which the case was brought by the because that particular point wasn't raised with any clarity in the proceedings below. Can I invite you to look at the plaintiff's summons?
Certainly.
When it was based. You'll find it at pages 5 to 9. You'll see that it, perhaps not entirely unusually, really consisted of a narrative of events beginning with the seizure of the goods in 1996 and then extending the history over a number of years. In paragraph 2, it is alleged that the goods were seized. After the original seizure, which, as we know, was evidenced by the memorandum of Kronstadt, set out the history of the prosecution and conviction of the appellant's director, Mr. Shanto, followed by the eventual.
Oh, was it? Very well.
We have got it in the record. There was then, apparently, an exchange of correspondence.
July?
We're looking at paragraphs 12 to 13 of the plaintiff's summons. And we'll see that on the 5th of January 2007, Mr. Shanto went along to the officers of the police who had the goods at that stage to take delivery of them. And that in paragraph 13, when the goods were shown to him, he said that most, or found that most, were not in their original boxes, and many were found damaged, and that he refused to take delivery of the goods at that stage, and sought to insist that there should be a further memorandum of Kronstadt. He then brought a civil claim in the Supreme Court, which you'll see paragraphs 21. The story of it is, it begins at paragraph 16. He applied against the police and was met with the response that he would have the goods back if he paid the duty which was said to be due, and that paragraph 21 was apparently alleged at least to be 820,000 rupees odd. And then he withdrew that claim. That was followed, according to the paint with summons, and I think this is accepted, by an exchange of correspondence which really was to a very similar effect. It was only after that that he began these proceedings in which he alleges in paragraphs 27 and 28 really that all these matters which I've just summarized can be drawn together, and as a result of them he, or rather the appellant, has suffered prejudice valued at 35 million rupees. The plaintiff summons doesn't put any figure on the value of the goods. There's a general claim for damages and the return of the goods, although in due course the claim was, as you know, increased to 65 million, and the claim for the return of the goods was abandoned. In fact, it's difficult to see quite how it would have got very far, bearing in mind that he had refused to take delivery of them back in 2007. But just for your note, 65 million is something like 1.5 million.
Yes.
In our submission, the respondents were justified in finding that pleading unsatisfactory. It didn't clearly identify a cause of action. Not only does it not clearly identify a cause of action, it doesn't identify the stage at which any cause of action is alleged to come into being. So if your lordship's to put to me, well, what about the situation after the acquittal? That doesn't seem to be the basis upon which the claim was being brought. And I heard my learned friend say that that was the way in which it was argued before the judge, but I don't think, with respect to him, that the transcript of the proceedings quite bears that out. And we do have the transcript of the
Yes, of course we
before
do.
the judge, and we do have his arguments. But
put that way to the Court of Appeal. Let's look at the judge first.
yes, but just before we do that, Lord, on the basis of that pleading, it is difficult to see how the respondents could be liable for the events that occurred during the time that Mr. Shanto was being prosecuted. And we know there was plainly a case which satisfied the magistrate. We've also got the judgment of the magistrate about that. And it's also difficult to see that he didn't know what the position adopted by the respondents was after that, because he was being asked to pay the 800 odd duty before he would have his goods back.
Well, that raises the question, Mr. Guthrie. Why was a defence never raised in relation to the alleged non-payment of duty? We are entitled to continue, we have been entitled to continue to hold these goods because you have not paid the amount lawfully due by way of duty.
Well, I can't give you a satisfactory answer to that. I don't know why he was not sued through the civil courts. Maybe he doesn't have any money.
As a defence, I mean.
Oh, as a defence to his claim. Well, as I say, it wasn't clear in my respectful submission that that was the way in which the claim was being put. And in any event, if the law is as the Court of Appeal found it, the plea of faute lourde was enough to answer it in any event.
Well, I think that's the question that's being asked. If you look at paragraph 28 of the plaint,
Yes.
it is being averred that they've never made any claim during the period of time which is prescribed by law for the duties and taxes. So that might amount to you are not entitled to the duties and taxes.
Well, it might do, but it's not clear that it does with respect to the lady, because...
Humour me for a moment, and if that's right, then the question would follow from that. Could retaining the goods in those circumstances, either by the police or by the customs, amount to faute lourde?
Well, respectful submission, that would be a matter for the courts below. They plainly, both of them, thought that nothing in the evidence could amount to folklore. I can give you the references.
Well, we know they find it, but the question is, are they entitled to say that?
Well, Lord, my lady, the difficulty, it seems to me, is perhaps when you say to me no claim was made, there is correspondence asking for the payment of the 800.
I'm not saying that no claim was made. I'm quoting from paragraph 28 of the plaint.
I would respectfully submit that, in fact, paragraphs 27 and 28 of the plaint are plainly disingenuous and indeed wrong, because we know that the plaintiff was fully aware of the allegation that there was under-declaration. He also knew that the respondent's position was that he owed 820,000 because they wrote to him about it. That letter of demand is in the record, the reference to page 170, and indeed in his evidence, which we have the translation of, he says at page 299, later we received a letter from MRA, that's the Revenue Authority, telling us that we must pay about 800,000, then they will authorize the police to return the goods. So the only possible lapse which they could be accused of would seem to be not actually bringing proceedings against him for the outstanding duty.
If I've understood it, a distinction is made in this appeal between the goods being detained or being actually seized by the customs. Is it?
Well, it doesn't.
Is there a distinction?
Well, with respect, on the facts of this case, it doesn't appear that there is a valid decision because they were plainly seized to begin with.
Were they entitled to retain them, putting in neutral terms, pending the payment of the duty?
Well,
they have no lawful authority to have them at that.
Well, I'm reluctant to start quoting from customs legislation, partly because I'm not sure I know it in any detail, but also it was never raised below.
Right.
And it would seem a little unfair to my learned friend, perhaps, for me to suddenly raise a statutory right which we didn't rely on below.
Well, Mr. Costello, I was wondering about what I thought at first was a distinction between what I may mistakenly have thought were the civil police and the Revenue Authority. But looking at the plaint, page 5, paragraph 2, and repeated at 4, what seems to be the plaintiff's case is that the goods were taken, to use a neutral expression, by the police squad of the Revenue Board. Yeah. Admittedly, the Revenue Board's predecessor, but that may not matter. So is there a distinction between the police taking the goods, the police of the Revenue Board taking the goods, and a formal seizure, as it were, on account of duty?
Well, my understanding of the reason that I'm representing two parties rather than one, the state are regarded as being responsible for the police and the Revenue Authority is responsible for the customs.
Well, that's what I at first thought, but looking at paragraphs 2 and 4, I'm beginning to wonder.
Well, the difficulty, my lord, is not of our making, it's of the plaintiff summonses making, because it doesn't make it clear exactly what is being said against whom.
No.
But my lord, may I just make a general point? I quite understand your lordship's wondering whether there was some express statutory power to retain the goods after the acquittal or something like that. There is a limit to the extent to which the appellant's case can be made for it. I mean, the judge below is being criticised for not having weighed in with various constitutional arguments which were never made. And the case which we had to meet was, as set out in the plaint with summons, in our respectful submission, it was very general, it was vague, and it wasn't tied to any particular area of time, and indeed it wasn't tied to any particular persons at any particular area of time. What the respondents did was raise first the plea in limine litis that there had been fault alleged. Now, the judge said, well, he thought that had been done, although the interlocutory judgment he gave at page 59 doesn't really say exactly how. We then did expressly raise, as my lord has pointed out, the faute lourde point. And indeed, we argued it. There was a notice of objection to our application to amend, which I think your lordship will find about page 65. But I think it's page 70, I'm sorry. It simply said that the amendment is not in the interest of justice, the more so that the defendant as employer is responsible and liable for the acts and doings of its employees. There was then, in addition to the notice raising the plea in limine litis, a hearing which was effectively devoted to nothing else.
Yes.
And that was an interlocutory hearing.
Well, we've got that on 77
Yes.
and following. And it all gets resolved, everybody agrees,
Yes.
that it can be rolled up with the main hearing.
Then in the argument before the judge, it is relied on by Mr. Reddy, who was respondents at the hearing first instance. We find at page 127.
Mr. Reddy represented the Revenue Authority, didn't he? Mr. Louis represented the state.
Yes, I think that's right.
Yes, very well.
But you'll see that at page 127, the argument is expressly made in detail. There's reference to one of the two main cases, Suknar. Mr. Talbot responds, but he doesn't say why is Mr. Reddy relying on there being no allegation of faute lourde. This is not just faute, it is faute lourde, and you can infer from the fact that we didn't get our goods back after 2006, the fact that they were motivated by faute lourde. My respectful submission, looking at the matter, a faute lourde is obviously an objective consideration, looking at it objectively on the basis of the way in which the case was argued and proceeded in the courts below. There really isn't any material on which one could say what faute lourde is. That faute lourde has been established. There is some assistance in the authorities which your lordships have as to what faute lourde means. Loosely translated as bad faith. It is also referred to as abus de droit. And I think it's in the case of Arsu, which your lordships will find at page 722 of the authorities bundle.
Yes, we've got it twice. I'm working from your copy of it, which is on page 65.
Yes, I think that the electronic reference is
maybe.
Yes, sorry.
Yes.
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 And at page 70, the judges say what constitutes faute lourde is not, however, subject to any rigid definition. For sure, it requires a degree of faute which is more serious than faute simple, that it finally remains a matter of appreciation from the court.
Rien n'est plus fluide que la notion.
Yes.
Yes, fine.
It may be that one looks at Terre in his book, it's une erreur, une négligence énorme, impardonnable, mais son auteur n'avait ni l'intention de nuire, ni même la connaissance du tort qui en résulterait pour le créancier. Apologies with that. But it isn't plainly, with respect, must be more than anything which is revealed in the story of this case. as to what happened between 2006 and 2007. Apart from anything else, it was clear on the plaintiff's own narrative of facts that he could have collected his goods if he had wanted to bring proceedings on the basis that there was a shortfall of them. He had the original constat to compare them with. No doubt he could have said, look, they've been damaged by the police and brought some sort of interference with goods on that basis. None of this can...
He could only have collected his goods, as I understand it, if he paid the duty that
No, not at that stage, Lord.
Right.
I think if one goes back to the narrative again,
You took us to that.
that point hadn't been taken at that stage.
Right.
He was offered them.
The
And it was only
narrative says
later.
that he wasn't prepared to take them because the boxes were gone. And there was
Yes, and
damage.
I think that was at an earlier stage than the correspondent which dealt with the amount of outstanding duty. But, well, I hope I've answered my lady's question. There's really nothing in this material which would justify possible finding of folklore.
Now, let me see whether any of my four colleagues want to ask any supplementary questions of you, Mr. Guthrie. It doesn't look as if
Thank
they
you.
do. Well, we're
Certainly
grateful
don't want
to
to
you.
say anything gratuitous.
We're grateful to you. So, Mr. Talbot, we've been pressing Mr. Guthrie with whether there's anything in the evidence from which one should or possibly even can infer faute lourde. And Mr. Guthrie has said no. Now, you've got a short right of reply.
Obviously, I beg to differ from the submission of my learned friend, because going through the authorities submitted by the respondent themselves, it is my submission that the manner the respondent had dealt with this prolonged detention, I would submit, if I were to infer from that, that can be something more serious than somebody, a public body, acting in such a way in respect of the property and the right of a citizen. This is arbitrariness. And there can be no worse fault than one of arbitrariness.
Well, thank you very much. Mr. Guthrie, you're on your feet.
Please forgive me. I had an obvious answer which I omitted to give to Lady Black's question of me, which is whether the Court of Appeal and the Court of Law were entitled to find as they did. And it's simply a reference back to my case. The fact that they both found as they did should weigh with this Court spelt out in my case, I think, but it would have been an extra answer.
Well, thank you, Mr. Guthrie. Mr. Talbot, the point is now made that both the trial judge and the Court of Appeal said no faute lourde, and Mr. Guthrie is saying it might be dangerous for the board to disagree with concurrent findings in your island's courts. Do you want to say anything about that?
I beg to differ, because your lordship are in presence of all the facts, of all the proceedings. There has not been any evidence adduced by the respondent. They have come forward, represented by counsel. They have put up their fight. They have raised points of law. I don't think what else can be done. This board has all the materials, and we trust that this board will come enough material to come to the decision in the interest of justice, and invite your lordship.
Well, Mr. Talbot, we are all extremely grateful to you for the help you've given the board today, and your junior, Mr. Chukabu. And we'll now take time to consider what our judgment should be. Thank you both very much indeed, and Mr. Guthrie.